Okay, folks. Thank you again for coming. Would you take up your Ettinger folder? It's got the scales of justice on it, and open it up, please. Great. On the right side, there's a page for notes, so you can take that out. That's for notes, if you like. Underneath that is a review of my book, Ettinger on Elder Law Estate Planning, on Amazon.com. So what is elder law estate planning? Well, it breaks down to estate planning, which has been defined as getting your assets to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. And we all need an estate plan. The mortality rate is alarmingly high. And estate planning has been around for a long time, about 1,000 years. Elder law, however, has only been around since 1988, when New York State formed a section of the New York State Bar known as the Elder Law Section of the New York State Bar. And elder law is of relatively recent vintage because it's only in the last 100 years or so that people have started living a lot longer. We live an average of 31 years longer than we did a century ago. And what's happening is, as a result of everyone living so much longer, more and more people are becoming disabled. They say about half of us will have a period of disability at some point in our life, usually late in the day, where we will be unable to handle our affairs. So the bar has recognized this and developed the rules concerning powers of attorney, who's going to handle your legal and financial affairs, healthcare proxy, living will, who's going to make medical decisions for you, including end-of-life decision-making, terminating life support, where there's no hope of recovery and no meaningful existence. There's the laws about guardianship if you become disabled. All the laws about Medicaid. What assets are exempt? What can you transfer? How do you plan ahead to protect yourself from losing all your assets from a nursing home? And all this falls under the area of elder law. And in this book, I actually argue, I believe, my firm believes, it's one subject. We call it elder law estate planning because we know everybody needs an estate plan, unfortunately. But we also know about half of our clients are going to need a good plan for disability, and because we don't know which half they are, we make sure everybody has it. And I believe the best way to illustrate this is to explain why we feel that wills are obsolete as an estate plan, at least for people 60 plus. And they have been obsolete, in my view, for at least a couple of decades. And there's 4 major reasons, and I'd like to go over them with you tonight. But first, may I see by a show of hands, how many people here have a will as their primary estate plan now? May I see by a show of hands? Most of you. Thank you. And how many have a trust set up? A couple. Good. Well, the first reason why wills are obsolete is because they take effect when? When you die, right? And that worked very, very well for quite a few hundred years. But it doesn't work so well anymore because today half of all people become disabled. Now, if you become disabled eventually, late in the game, if you become disabled, does the will help you? Clearly not. So the will is not a plan for disability. So what do you think happens to all these people every year who become disabled and they don't have a plan? New York State has written a plan for them. You've probably heard of it. It's called guardianship. If you can't handle your affairs and you don't have an adequate plan, a judge can step in and appoint someone to handle your affairs for you. That's called a legal guardian. Now, would anyone here care to take a guess as to who you think the judge might choose? Any guesses? Shout them out. Child?
Some lawyer.
Some lawyer? Those are actually 2 very good guesses. Some judges feel that your son or daughter have a conflict. The conflict being, if they spend the money on you, it's coming out of their inheritance. So often they like to choose a local attorney. I've been picked. And the first thing I would do when I'm picked as a legal guardian is collect up all your assets, investments, bank accounts, insurance, IRAs, move everything over to my good friend, Mr. Dinallo at Wells Fargo. because I'm in charge of the money and I have to put it in a place where I feel comfortable. I know I have to file an annual accounting with the court, and my law firm can be held liable for any losses, so I'm going to put it in a very safe place, not only with a firm that I like, but also with a person that I trust. And furthermore, I'm going to ask them to invest it in guaranteed investments that can't go down. So essentially, I've discharged my fiduciary responsibility. That's not actually the problem, that Attorney Ettinger or someone else is in charge. The problem is today a lot of people recover from disability, stroke, heart attack, serious operations. Now when you recover, do you think you can take back control of your assets whenever you feel ready from the legal guardian? What do you think? Anybody? I see some heads going no. No, because there's a court order putting, in this case, Attorney Ettinger in charge. To get back control from a legal guardian, you have to go back to court and have a trial and prove to the judge's satisfaction that you're able to handle your affairs, so the judge cancels the order, puts you back in charge. Can you see yourself here? You're in your 80s or 90s, in court, on trial, fighting to get your own assets back? Not a happy situation. I've seen it myself. And fortunately, it doesn't happen for the vast majority of our clients because they almost all use trusts. And one of the best reasons to use a trust is because a trust avoids guardianship. And the reason trusts avoid guardianship is because unlike a will, which takes effect at death, a trust takes effect while you're living, which is why they call them living trusts. So what happens in a trust essentially is you're saying my estate starts today, not when I die. And for now I'm putting myself in charge. So we call you the trustee of your trust estate. Now, if you start your estate today, you can write in your own plan for disability. You say, I'm in charge now, but if I become disabled, I name so-and-so to step in. Well, the law says when you set up a trust where you name a backup trustee, this defeats a guardianship. So the judge cannot appoint a legal guardian for you if you said who you wanted, only if you didn't say who you wanted. So in the event of disability, you're going to get the person or persons you choose. Now, do you think it's going to make a difference if your people are in charge or the state's in charge? What do you think? Big difference, right? For many reasons, social, psychological, but the biggest reason is the financial reason. Because your people obviously are going to act in your best interest. And I'm going to explain the difference between having your people in charge and the state in charge. In all of these elder law estate plans we've created over the years, many thousands of them, you folks, the clients, choose someone that you trust, and you authorize them to move your assets out of your name if you need long-term care, nursing home. You might choose two people to act together, but one or two people generally. And we call this the unlimited gifting power. And the reason in the elder law estate plan you choose someone or two people acting together to move your assets if you become disabled is because we know under the Medicaid law, if you have to go into a nursing facility, it's move it or lose it. So let's say, for example, a son comes to see us and he says, Mike, you set up my dad's plan 23 years ago. He has to go into a nursing home tomorrow. He has about $500,000 in assets left. Can you help us save anything? We'll say, as a matter of fact, yes. Under the Medicaid law, we can take half of what he has, gift it to the children. As long as we spend the other half on dad's care, the family gets to keep the half. So he has $500,000, gift half of $500,000, which is how much? $250,000, gift that to the children. Remember, we have the unlimited gifting power, so we can move that money. As long as we spend the other $250,000 on dad's care, the family gets to keep the $250,000. You can do this right on the nursing home doorstep. It's an advanced elder law technique, and it has a nickname. We call it half a loaf planning. How does that expression go? Half a loaf is what? Better than none, right? Sure. And later on, I'll show you can actually save the whole thing, but to do that, you have to plan 5 years ahead of time with a Medicaid Asset Protection Trust. We'll get there. But for now, you can save half on the doorstep because your family's in charge and they have the right to move the money. But what if you're the type of person that says, well, this didn't happen to my parents, so it's not going to happen to me? Or you're the procrastinator. I'll cross that bridge when I get to it. So you get to the bridge. Where's the bridge? Around 86 years old or so, the average age of a nursing home entrant. Now, in this case, you don't have a plan, so the state appoints a legal guardian. Let's say you still have the same $500,000. Do you think the legal guardian could take $250,000, gift it to your children for safekeeping? What do you think? No, because the guardian can only spend the money on the person they're guardian for. You get the state's plan, spend it on you till there's nothing left. So, the first reason why wills are obsolete is because there's no plan for disability, which is going to happen to about half of us, and you risk getting the state's plan, which is they appoint a legal guardian, and that person simply spends it on you till there's nothing left. And in my experience, the last 24 years or so, I've come to the conclusion that planning for disability is more important than planning for death. And the reason for that is twofold. One is, planning for disability is for who? For you, right? And planning for death is for them, essentially, right? Well, of course, you come first. But the other thing is, if you don't plan for disability, there might be nothing left for them. Because nursing homes in our area today have reached the almost ungodly sum of $15,000 a month. And you're responsible for up to 5 years, if you last that long. Well, what's 5 years at $15,000 a month? It's $900,000, which is sure to do a serious dent on anybody but the most well-off, including wiping out financially many, many middle-class people. So we believe you have to have a plan for disability more than you have to have a plan for death. And we'll get to the Medicaid Asset Protection Trust. But first, I'd like to explain how trusts work in general. And we're going to start with the Revocable Living Trust. This Revocable Living Trust avoids guardianship. And here's how they work. Let's say your name is Mary Jones. We set up something called the Mary Jones Living Trust. It's a separate legal entity, but you control it because you appoint yourself, Mary, as the trustee. So you're manager of the trust which you created, and you also name yourself the beneficiary, the person who has the exclusive use and enjoyment of the trust assets. So you're Mary manager and Mary beneficiary. Now, for a trust to work, you have to put your assets into it. You do that by retitling assets. So let's say you have a home here somewhere in the Hudson Valley. We'll prepare a new deed, and we'll deed the property from you, Mary Jones, to Mary Jones, trustee of the Mary Jones Trust. We'll get that deed recorded in the county and returned to you. We'll show you how to change the name of your investments, bank accounts, except for IRAs, which we'll get to later. They don't go through probate. You'll see we don't have to put them in a trust. But non-probate, non-IRA type assets, investments, bank accounts, will retitle to the trust so that your accounts read Mary, trustee of the Mary Trust. And then you carry on the same as before. You file the same income tax return as before. You buy and sell the same as before. Everything's exactly the same, except like tens of millions of people around the country, your assets say Mary, trustee of the Mary Trust. Nothing happens until Mary dies or if she becomes disabled. Remember, now we have a plan for disability. And what's the plan? Well, in the Mary Trust, you've named one or more backup trustees, and if you become disabled, they take over with minimum fuss, just an affidavit, which we would prepare, and they follow your instructions, which essentially are take care of me, keep my affairs in order, until I am in a position to take back the reins. Because today a lot of people recovering from disability, and you'll take back the reins when you feel ready. A private matter between you and your family, not going to court and asking a judge for permission, which might be denied. Of course, if you don't recover, you need long-term care. Your people are in charge to do whatever your elder law firm and they deem best on your behalf. So the revocable trust avoids guardianship because, as I said, if you have somebody in place in legal structure, there's no need to appoint a legal guardian. A number of cases say exactly that. If you have a revocable living trust set up and your assets are in it, no need for a legal guardian. So first reason we use trusts, avoid guardianship. The second reason we use trusts is to avoid probate. And what is probate? Well, when you have a will, it has no effect until it's proved to be valid, which means when somebody dies, the executor cannot act until the court approves the will. So the executor has to prepare a petition with, of course, the lawyer's help, serve it on the heirs and the potential heirs. They have to do an accounting and inventory. They may have to post a bond or anything else the judge requires. Well, as you know, a court proceeding takes time and it costs money. If you have a trust, it doesn't take as much time or cost as much money because there's no court proceeding. Trusts do not have to go to court to settle. So, we get a fee, for example, to probate a will of up to 3% of an estate, which is not unusual. So take that $500,000 estate. A fee of up to 3%. What would 3% of $500,000 be?
15.
About $15,000, right? If we have a trust, we get a fee of up to 1%. Well, 1% of $500,000 is $5,000. So why would it be up to $15,000 to probate the will, but only up to $5,000 to settle the trust? The $10,000 difference is the cost of going to court. And it can often be more than $10,000. It could be a few $10,000 bills. So you're likely to save considerable money not going to court, which of course everyone knows. You also save time. Kiplinger's once said it takes up to 2 years to probate a will in New York. We settle estates, and been doing it for more than 2 decades, in weeks, but usually months. But it very rarely takes years because you don't have the court proceeding. So you save money and you save time, but there's something else. And this is how I ended up as an estate planning lawyer. I used to be a litigator from 1980 to 91. And I was actually in my car riding down the Taconic State Parkway in late 1990, listening to the radio. I was chasing an ambulance. And you know what that means. I was on a personal injury call. And I was listening to the radio, and I heard on the radio, if you set up a trust, you don't have to go to court to settle. And I thought, wow, I'm not sure if that's correct, but that would be great if it was true. I had already litigated a number of estates. I knew there were a number of potential problems with wills. So I looked into it, and I found out not only was it correct, but at the time, the best estate planning lawyers were in Florida. Why do you think? Can figure that one out. Well, so I went down to Florida, got trained with some very good estate planning lawyers. I came back and I closed the litigation practice and I opened the estate planning practice. Actually, I didn't know about elder law at the time. It was so early in elder law's beginning stages. It was only a year or two later that I found out about it and picked it up as another subject matter that I felt we needed to master. But the first reason I got involved in this field was I wanted to keep my clients out of court. Because when you go to that probate court, who's in charge? The judge, right? Now tell me, does a judge always act in your best interest? No. Does a judge ever make a mistake? Every case I lost, the judge made a mistake. And when the judge says jump, your answer has to be what? How high, Your Honor? Now, you know, with all due respect, if you have to go, you have to go. But here, you don't have to go. Much less, are you going to send your nearest and dearest down to the courthouse to ask a perfect stranger there for permission to get the assets from you? Does it sound absurd? You know, it is. ARB said this 23 years ago. In 1991, the ARP did a study of the probate system in all 50 states, and they published a report. It was called A Consumer Report on Probate. And here was the conclusion in the report. ARB said that probate as practiced in the United States today is an anachronism, inappropriate in all but the most exceptional cases. And they advised the membership to stop using wills and start using trusts. And that actually started the living trust revolution. Since 91, tens of millions of people have set up the trust. The second reason, avoid the expense and delay of a probate court proceeding for my loved ones after I'm gone. Just makes perfect sense. The third reason why wills are obsolete, and we're going to cover 4, is wills are single generation planning. And there's somewhat of a hidden defect in the average will, and I'm going to explain it this way. Most wills read as follows: to my children in equal shares per stirpes. Now, what does the per stirpes mean? Does anyone know? It means, if heaven forbid my son or daughter dies before me, their share to their children. Does that sound familiar? Did anyone here say, if my son or daughter dies before me, I leave their share to my son-in-law or daughter-in-law? Did anybody say that? No. But what happens in the real world? In the real world, most children survive their parents. So let's say you have a son. Okay, we're going to call him Bobby. And in your will, you left Bobby $400,000. Parent dies, Bobby gets the $400,000. Unfortunately, 3 years later, Bobby dies. Who gets the $400,000 from him? Oh, your daughter-in-law. Oops. Can she get remarried and share your $400,000 with a complete stranger? Well, she will, because people live 31 years longer than they did a century ago, and so many more people get remarried. So, in order to prevent this from happening, here's what people are doing. They're coming in today and they're setting up something called an inheritance trust for their sons and daughters. So, instead of leaving the $400,000 to Bobby, they set up a Bobby trust. They say, Bobby, I set up a trust for you. I'm leaving your $400,000 to the Bobby trust, and I appoint you, Bobby, as the trustee. You're in charge. Parent dies, $400,000 goes into the Bobby trust. He's in charge. And he can do whatever he wants with the money. He could buy, sell, trade. He can spend the whole thing. You're not ruling from the grave. But the Bobby trust has 3 benefits. First, it says, Bobby, if you happen to get divorced. What's the divorce rate these days? Maybe half? Spouse can't touch it, separate property protected by the trust. Already makes sense. It says something else. It says, Bobby, if you get sued. Who gets sued today in this country? Everybody, right? Well, creditors can't touch it. Not in his name, not his social security number. Lawsuit proof. But the third thing, and the main reason people set up this trust says, Bobby, when you die, well, it could be 5 years after me or 50 years after me. Whatever you didn't spend, that's still in my trust. So I direct whatever you don't spend on your death goes to your children. In other words, my grandchildren. What if he doesn't have children? Then it goes to Billy and Mary, the brother and sister. Then it goes to niece and nephews. Always passes by blood instead of by marriage. Keeps your money in your family for generations to come. Does this sound like a good idea? Must be. It's what most people like to do, find out about it. So the third reason why wills are obsolete, they tend to be single generation planning. And as many of you know, it often ends up with second spouse and doesn't go down to your family and doesn't keep it in your family for the next generation. So that's the inheritance trust. And then the final reason why wills are obsolete, and we're coming full circle here, is that they do absolutely nothing to protect your assets from the extraordinarily high cost of nursing homes. So you have a will. So you have your executor name, and you have your successor executor, and you have your beneficiaries, and you have the percentages, and it may be in a very nice envelope with calligraphy on the cover. But unfortunately, client went into nursing home got everything, the family got nothing. You know what that plan reminds me of? The old saying, the operation was a success. Everybody knows the rest of that one. Yeah. Well, it's exactly the same thing, isn't it? I mean, I had a great estate plan, but there were no assets left to pass to my family. So, for more than 2 decades, it's been the opinion of our firm that for an estate plan to be effective, it has to have a means or method to protect the assets from nursing home costs, and it's really not all that difficult. You essentially have 2 choices. We call them Plan A and Plan B. Either you have adequate long-term care insurance, or you set up the Medicaid Asset Protection Trust. So let's look at your 2 options. First, may I ask again, by a show of hands, how many people here have the long-term care insurance? couple, right? Good. Long-term care insurance is Plan A for a reason. It helps you stay out of a nursing home. It pays for home care. The trend today is to age in place. Well, it may cost a little more than you can afford. So what the long-term care insurance does, it stretches your own dollars for months or years longer than you could if you didn't have it. After all, no one wants to end up in a nursing home because they couldn't afford to stay in their own home. So number one reason, to pay for home care so I can afford to age in place. The second reason I like the long-term care insurance is if you have a spouse, sometimes one of the spouses becomes disabled. And disabled is a term of art. It means unable to perform any two or more of the activities of daily living. They're called the ADLs, activities of daily living, and there's 6 of them: washing, dressing, toileting, transferring, feeding, and continence. If you can't perform 2 or more, you're considered, quote, disabled. What if it's your spouse? Well, you find out fairly quickly it can cost you $5,000-6,000 a month to bring someone in. And what many people do is they say to themselves, well, if I start spending that kind of money, I may not have enough left for myself, so I think I'll do it on my own. Well, this has turned out to be such a problem that the Alzheimer's Association commissioned a study on it, and here's what they found out. Over 60% of spouse caregivers die first. Why is that? Anyone? Stress, yeah. Well, the caregiver themselves is not in their 50s or 60s. The caregiver is in their 80s or 90s. The job is a very hard job, as you know, but not only is it a very hard job, it's 24/7, 365. So no wonder people get burnt out or worse. With the long-term care insurance, if you're unable to perform any 2 or more of the activities of daily living, that triggers the benefit under the policy, and instead of the spouse doing the heavy lifting, the insurance company sends a caregiver. So the caregiver does the heavy lifting, and the spouse doesn't wear themselves out, but also the spouse gets respite. What's respite? A break, right? They're not on 24/7, 365. So lawyers in New York do not sell insurance. It's a prohibition, and that's one of the reasons why I always have help here in the form of a financial advisor who can sell long-term care insurance. And when I say sell long-term care insurance, what I really mean is, as an elder law attorney, I encourage our clients to look into the matter, get the thing worked up, and then make your business decision. Determine, based on your age, your health, your income, your assets, how much you need. And then they'll shop it around, get your 4 or 5 quotes. And then you and only you will make your business decision. Am I going to insure against the risk, or am I going to risk my own assets? But I don't think you can make that decision without knowing what the numbers are. So look into it. Now, and you'll have the opportunity to do that later on. We'll give you that option. We know for a fact that the majority of people will not get long-term care insurance either because they get turned down for medical reasons, they cannot afford it, or they could but they won't pay the premium, or they waited too long. Essentially, when people get past 70, the premium goes beyond what people are willing to spend for this type of coverage. So if you're not a candidate for long-term care insurance, which I say is the majority, then you're looking at Plan B, the Medicaid Asset Protection Trust, the Medicaid Trust for short. The Medicaid Trust is an asset protection device that's been around as long as I've been practicing, which is going on 35 years. The Medicaid Trust is not the revocable living trust. The Medicaid Trust is an irrevocable trust. And the reason you need a different type of trust is because in the revocable living trust, remember we said you're married, trustee of the married trust, that doesn't shelter your assets from a nursing home because you can take it out at any time. Well, if you can get it, they can get it. So revocable trusts are good. They avoid probate, they avoid guardianship, they can help keep your money in the blood, protect it from your children's divorces, lawsuits, and creditors, but they can't protect it from a nursing home. To protect it from a nursing home, you have to use a different type of trust, called the Irrevocable Medicaid Trust because that trust sets up two roadblocks that Medicaid and nursing homes simply cannot break through. The first roadblock is someone else needs to be named as the trustee, usually one or more of the adult children. Medicaid has no control over them. And the second roadblock is, in a Medicaid trust, you must limit yourself to the income only. You put in stocks, you only get the dividends. CDs, you only get the interest. Your home, it doesn't earn income, so you get the equivalent of the income, exclusive right to live there, use and enjoy the property during your lifetime. What happens to these assets? They stay in the trust, and then they go to your heirs free of the expense and delay of a probate. So who sets up these Medicaid trusts and why do they do it? Well, middle-class people, in my experience, generally 70 plus. Why 70 plus? Well, the revocable trust, we're talking about 60 plus. The reason the irrevocable trusts we start at 70 plus is because we know if somebody doesn't have long-term care insurance by 70, they're very, very likely not getting it. And we also know there's a 5-year look back, which I'll tell you a little more about, but it takes 5 years before all your assets are protected. And we know the average age of a nursing home entrant is about 86. So starting at 70, we want to try to get those 5 years under our belt. So generally, people 70 plus have a lot of assets that they're not going to spend, like their homes. For heaven's sakes, move to protect your home, because if you don't put your house in a Medicaid trust and you get ill, they put a lien on your house, and if the lien is running $10,000 to $15,000 a month, you know that it's not going to be very long before the lien is worth much more than your house. And of course, this happens all the time. People have to sell the house and they owe the county more than the house is worth. Not a happy situation. So protect your house. You take your home, you put it into the Medicaid trust. The trust says you have the exclusive right to live there, use and enjoy the property. You keep all the exemptions. Can you sell the house? Sure. The trust sells the house. The money's paid to the trust. The trust can go out and buy a condominium. The trust can invest the money. And because of the sale of your house, you will probably have enough income to pay for a rental if that's what you choose. Or you could trade down to a smaller house. But the trust can sell and buy. So you protect your house. Now, I said anytime after 5 years, the house is protected. Well, what if you don't make the 5 years? What if 4 years go by and you have to go into a nursing home? In that case, you only have to pay for the 1 year that's left. You already have the 4. So it always pays to get started. We do it for people in their 90s. We do it for people whose health is failing or questionable because they know if I get a couple years under my belt, I don't have to pay for the 5. I only have to pay for 3. So it always pays to get started. What else do we put in? Well, let me address that by saying what we don't put in. We don't put IRAs into the trust because IRAs are exempt from Medicaid. And not just IRA, but any type of money that's qualified, which is IRA, 401k, 403b, TDA, TIA-CREF, 457, KEO. Any of those qualified plans are exempt from Medicaid. By that I mean the principal is exempt. The principal is exempt. The income is still available. And by this I mean if you're over 70 and a half, and well, put it this way, if you're in a nursing facility, you're probably over 70 and a half. And that means what for your IRA? If you're over 70 and a half, you got to take, right? You're taking, some people call it the RMD, required minimum distribution, some call it the MRD, minimum required distribution. Either way, you have to take a certain amount. If you're in a nursing facility, they get the required distribution because you have to take it. That's income, and they're entitled to your income. Your income is not going to be $15,000 a month. It might be $2,000 or $3,000 a month. They get that, but they can't take the difference out of your principal. That's protected. So the principal is protected, and as I mentioned earlier, we don't have to put the IRA into a trust because IRAs don't go through probate. They have a designated beneficiary, right? So the IRAs don't go in. But here's what I'd like you to consider. If you have non-IRA money, stocks, bonds, mutual funds, CD, money market, savings accounts, let's say you have $400,000 in those non-IRA assets. What I'm going to want to know is, are you spending that principal? Do you need that $400,000 to live on? Now, a lot of people 70 plus tell me, no, I don't need that $400,000 to live on. Some people tell me we're just reinvesting it. We have enough income. Some people say, well, we're not spending the principal, but we're taking what it earns, either the interest or the dividends, whatnot, but we're not spending the principal. And what I tell those folks, and I'll tell you, is if you're not spending the principal and you don't need it to live on, do you know that you're actually safe keeping it for the nursing home industry? Well, here's what happens. Client's 70. You know how life is. One day you're 70, another day you're 85. What happened? You still have the same $400,000 because you didn't spend it, but now you find you have to go into a nursing facility. Over in the business office, they're jumping up and down. Why is that? Well, and they know, you're going to be paying them the $15,000 a month. Now, do you know that about 3/4 of the residents in that facility are on Medicaid? Is Medicaid paying them $15,000 a month? No. Are you getting the same care as everyone else? Yes. So what happened? They just hit a home run with your money. And it's totally unnecessary when you can put it into the Medicaid trust, still there if you need it, but somebody else can't come and take it away from you. So type of thing we talk about in the consultation, whether you should have a trust or a Medicaid trust. We'll get to that in a moment. But a couple of maybe comments about the irrevocable trust. A lot of people are very uncomfortable with the word irrevocable until they find out in New York you can revoke an irrevocable trust. Isn't that terrific? How could that be? Well, it's irrevocable because you cannot revoke it yourself. So the law says, as far as you're concerned, you're known as the grantors, it's irrevocable. But New York has a wonderful rule on the books that says that if every person named in an irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. Well, who's that? It's you, the trustees, one or more of your children, the beneficiaries, the rest of the children. So if you and your immediate family sign off, you can always revoke it. So there's a way to undo it if you need to. And you also do reserve the rights to change who the trustee is in case you have a falling out. You reserve the right to change who you leave it to. And you reserve the right to make gifts out to your sons and daughters. So you can still continue a gifting program or pattern that you had before you set up the trust without affecting the 5-year look back. So that's the sum and substance of my remarks. Now let's talk about where we go from here. These principles, a revocable trust, avoiding guardianship, avoiding probate, keeping in the blood, protected from children's divorces, losses, and creditors, protected from nursing homes. This applies differently to everybody. And so what I'm going to offer you, and we've been doing this for over 2 decades, is to come in to see me for a free consultation. It's a follow-up consultation to see how this applies to you. And let me explain how that works. I'm going to ask you to go into your packet and take out in the back, there's a blue form. So if you would take that out, and we're going to look at it together. It says Confidential Planning Survey.
Do you have another copy? We need to.
I do. If you would help yourself, they're up on the table there. There's a couple.
Okay, thank you.
You're welcome. So everybody have that, your confidential planning survey? Let's look at it together. First it asks for your name, spouse if you have one, your adult children. If you're single, I wrote a chapter in my book on estate planning for singles. We can talk about that. Put down the names of your adult children. Then at the bottom it says, or if you're a couple, our primary planning concerns are, check all that apply. Planning for disability, you may want to check that. Elimination of probate, almost everyone checks that. Keeping assets in the bloodline, if you're interested in the inheritance trust, you want to check that. Planning for elderly parents. If you have older parents, you may want to talk to them about the Medicaid Asset Protection Trust. They could already be protecting their assets at the rate of $15,000 a month. You can talk to your siblings, your adult brothers and sisters, and any of those folks, your parents or siblings, can watch this seminar on the internet on our website. I'm sorry, we agreed to hold the questions till the end, so I'll take that after. So they can watch this seminar, and that's the purpose that this is being videoed, so they can watch online and learn what you've listened to. If you have special needs children or grandchildren, we can provide for disabled heirs with something called a special needs trust, so they don't lose their Social Security and Medicaid benefits because they got an inheritance. They can still get the inheritance, but it has to be in a special needs trust that only pays over and above what the government pays. On the right side there, if you want to protect your assets from nursing home costs, check that. Protecting assets from spouses' remarriage. What's that about? Well, I'm going to address this to ladies in the audience for a moment. Ladies, you may not think he's much to look at, but I want you to know if something happens to you, he's a chick magnet. You know, one of my clients said this to me from right here in Rhinebeck. You can't make this stuff up. She points to her husband, he's 76 years old. She says, you know, he's a chick magnet. I mean, I would have never guessed this in a million years, you know. But what happens, this is a big issue today. What happens if wife dies first? Aren't there an awful lot more women than men? Yeah. Don't people live a lot longer than they used to? Yeah. So what does that mean? The chances of remarriage keep going up every year. Now, let's say your husband gets remarried. Who do you think's going to die first in that relationship? Him, right? Who's going to end up with all the dough? Her, right? What's going to happen to your children out in the cold? Anybody here hasn't seen this happen, either in their family or friends, relatives, acquaintances? It's universal, but it's an increasing problem because people are living longer all the time. And the longer people live, the more chance of this occurring. So how do you protect the assets? Well, a trust is wonderful for this purpose because in the trust, you can say husband and wife are trustees. They're both in charge. If wife dies, husband and children. If wife dies, husband and children are co-trustees. Right? Which means what? It means while husband gets remarried, spouse number 2 won't be able to get his or her hands on the assets. So if this is something or a type of protection you're interested in, check yes. I want to protect the assets of my spouse's remarriage, and we'll talk about that in your consultation. Divorce and creditor protection for the inheritance, that's the inheritance trust again. Protecting children from poor spending habits. Is there anyone here who has children with poor spending habits? All rise. Thank you very much. Okay? We'll talk about that. You can hold it back. You can spill it out over a period of years. You can put somebody else in charge. You can give them an income only. A lot of options there. Next thing is out-of-state property. May I ask, by a show of hands, is there anyone here who owns out-of-state property? Couple. Where's that?
Maine.
Maine. And yourself? Florida. Well, what happens if you die with a will and you own property in another state? Do either of you know? We have to probate the will in New York and Florida. New York and Maine. But that's not the same lawyer. It's not the same court. So it's 2 probates. And in fact, it's called the multiple probate problem. And it's the easiest thing to avoid. When you set up a trust, we can deed any one of the 50 states into the trust. You avoid all the probates. It's a good thing to know. Recommended not to use a will if you own property in more than one state. Now, if you open it up, inside there's some yes-no questions. Tells you what to bring with you. Bring your will. Bring your trust. Bring your power of attorney, healthcare proxy, living will. Bring the deeds to your property and the real estate tax bills. Statements from brokerage accounts. Your long-term care policies. Fill out the financial information. And here's what happens in the estate planning process. It's very low-key. There are generally 3 meetings. In the first meeting, we're getting to know each other. So I'll interview you about your family, your adult children, what kind of work do they do? Are they married? What's your son-in-law's name, daughter-in-law's name? Do you like them? You don't like them? That sort of thing. What's the family, and your grandchildren, how old are they? What are their names? What's the family dynamic? And this is rather easy because everyone knows their family. So I get to know your family from your point of view. I look at your assets, I look at your income, and I look at your current plan. And the first thing we're looking at, does it represent your wishes? Are these still the people you want in charge? Are these still your beneficiaries? Are these the right percentages? And then I'm running through, in my mind, a checklist rather quickly of the things that you may not have? Do you have something to avoid probate, something to avoid guardianship, something to keep it in the blood, something to protect it from children's divorces, losses, and creditors, something to protect it from a spouse's remarriage, and do you have something to protect it from the extraordinarily high cost of nursing homes? If you don't have something, which I think you need, I'll tell you. But first I want to say, we built the firm and we have a reputation. If you don't need something, we'll tell you. If you should wait, we'll tell you. If you're okay with what you have. If you should do it somewhere else, we'll tell you why. If you can do it less expensive or simply even do it on your own, we'll tell you how and why. But if you do need something, and we think we can help you, we'll tell you that too. And you folks would meet with me. There's other lawyers in the firm give the seminar. People meet with them. But I'll tell you if I think you should do something, what I think you should do and why, and what your options are. I'll give you a copy of my book, which is a thank you for coming. And I'll also ask you to read those chapters that apply to your situation, maybe chapters 1 to 6 and 20 or whatever applies. And I will also tell you what the fee will be if you decide to go forward. We're not actually doing business in the first meeting, but people really like to know where they stand. And doing it for almost 24 years, we know what the fees are. So we share that with you. But we give you time to think it over. And also you have to make some decisions. You may have to bring in some missing paperwork. You may have to talk to some other people about things. So we'll make another appointment generally between 2 and 4 weeks later. If we're moving forward carefully. Somewhere in the next 2, 3, 4 weeks we'll have another meeting. You've read the chapters that apply to your situation. You bring in any missing paperwork. You've thought about it. You've made some decisions. And I'll draft the estate plan together with you. And at that point I'll give you a 2-page proposal in writing. And generally, by the end of the second meeting, most people are decided if they want to go forward or not. And if you decide to go forward, we say fine. At my firm, we don't take a retainer. And instead, we'll say fine. Don't give us any money now. Let's prepare the estate plan. You'll come in, another 2 to 4 weeks later. We'll review everything. It might take an hour and a half, 2 hours. We'll review the trust, healthcare proxy, living will, power of attorney that we drafted. We will review and sign a pour-over will, P-O-U-R, which cancels the old will and says if you left something out of the trust, pour it in there after you're gone. We'll execute any deeds for assets going into your trust. And then after everything's done and you're completely comfortable and you're set and you're happy and we're happy, then we accept the fee. And we're very careful about that because we really want to make sure that you understand it, you're comfortable, you want to go forward. And we have a special reason for doing that too, because whereas the majority of firms, when you sign, they say goodbye, and that I've even seen the bar recommend that. I had that in my continuing legal education. They recommend after you do the estate plan or after it's executed, you send the client a letter saying this concludes our representation of you in this matter, so that that starts the statute of limitations running, so that if we made a mistake, you can't sue us after a few years. But we do just the opposite. I believe that's a very, very poor and incorrect approach. I don't care for it. We actually do the opposite, and it's very rare. In fact, we actually have a process trademarked, and it's designed to make our plans work when you need it. Because the traditional plan and the type of planning that lawyers train other lawyers to do, I actually believe there's a defect in traditional estate planning, and it's this. When you signed your will, maybe it was 10 or 15 years ago. Remember that? Yeah. So after you signed it, were you planning to use it the next couple of weeks? Anybody? No, right? You're hoping to use it a minimum 50 years later, right? Well, what chance do you think 50 years later, executors, the same person you wanted 50 years ago, or the beneficiaries are the same, or the percentages are the same? Probably not a very good chance, right? And in fact, this happens so often. When someone dies, they trot out the old will, causes a lot more problems than it solves. Why? I believe it's a defective design. That will or estate plan is designed to work when you signed it, not when you need it quite a few decades later. So I invented a process, and I trademarked it in Washington in '99. It's called the Ettinger Elder Law Estate Planning Process. And it's actually designed to make the plan work when you need it. And it's rather simple. We have a computerized software program so that when there's a law change, we can actually search the whole database and determines which client it applies to. We have a client breakfast every 2 years. We invite you to come in. update you on the law, what's happening in the firm, and we invite your next of kin to meet the lawyer. Once a week, we send all our clients a law letter. It comes by email. It's called the Ettinger Elder Alert. And the law doesn't change every week. It might be social one week, legal, medical, financial, but we get very good information in the firm, so we share it with you. But here's the key. After people sign with us, we don't say goodbye, we say hello. Now, we promise that we will review it every 3 years. And every 3 years, in fact, we send you a letter. Time to come in for your free review. So we don't disengage, we engage. Come in every 3 years for a free review. And here's why we want you to come in, because we have no other way of knowing. Did your health change? Have your assets changed? Your family? Births, deaths, marriage, divorces? Something else happen? So here's how it works, because I've been doing it for 15 years now, since 99. Clients come in after 3 years. Very few people need a change. But I make sure to tell you how much younger you look than last time I saw you. 6 years later, naturally, after 6 years, more people need a change. But do you know that almost no one gets past 9 or 12 years without needing a major change? Who's in charge, who they're leaving it to, something else happened. So you do an amendment. Today's dollars, it's $375, so not too terribly serious. But you update the plan, and then you're good to go. The point is, when you go to use the plan, it's never more than 3 years old. Designed to work when you need it, not when you signed it. We saved an awful lot of people an awful lot of trouble with that system. And the other thing is we're building the relationship. So in a dozen years, we may see a client 8 or 9 times. Well, don't you think it makes a difference when something bad happens? The lawyers, you usually meet more than one, the staff, and it makes a tremendous difference. I mean, I have a couple of staff members this year celebrating their 20th anniversaries. I've been with the firm 20 years. And it's nice when something bad happens that you know the firm and you know the people. And it's nice for us, too, because when something bad happens, we know who it is. And it makes it easier for everyone to deal with. So I recommend it to you. It's a no-charge service. You pay as you go, but it's working for you all the time. So now I want to thank you for coming and thank you for listening. And that concludes my remarks for this evening. Thank you very much. Thank you.